to that, Nick. We'll get back to you. We got the breaking news from the Supreme Court. We've been waiting for this. Decisions coming down in the Hobby Lobby and Harris versus Quinn cases. Rich Edson is there with the details. Rich, what can you tell us?
Maria, Justice Alito writing, we hold that the regulations that impose this obligation violate the law which prohibits, pardon me, they usually give a smaller booklet than this large one here, the federal government from taking any action that substantially burdens the exercise of religion unless that action constitutes the least restrictive means of serving compelling government interests. In holding that the HHS mandate is unlawful, we reject HHS's arguments that owners of the companies forfeited all their RFRA protection when they decided to organize their businesses as corporations. So basically, in plain terms, it makes it clear that Congress did not discriminate in this way against men and women who wish to run their businesses as for-profit corporations in the manner required by their religious beliefs. This is a victory for Hobby Lobby right here. We're going to go through it and see how deep the victory goes for Hobby Lobby, how broad-reaching it is. This is me just picking up the opinion right now, Maria, also on the heels of a major union decision, this one, and let me pick this up here. In the smaller booklet we were talking about, where the Supreme Court found that basically if you're a public employee of a union, but you're part-time, you're a home health personal care worker, they said if we allowed that union compulsion, that you have to join a union and pay dues, to be extended to those who are not full-fledged public employees, it would be hard to see where to draw the line. So a slight loss for labor. It's a narrowly written decision there. Hobby Lobby wins in this one. That's, of course, the case that basically said the HHS mandate that Hobby Lobby and other businesses had to provide funding in their health care plans for contraception. Hobby Lobby argued because of its religious beliefs it shouldn't have to do that. So the court finds with Hobby Lobby here. Not sure, at least the full specifics on how deep this decision goes. We're going to take a dive and see how deep it does.
All right, Rich, stay with me right here. I'm with Joe Tacopina on set. And, Joe, this is the contraceptive mandate. What's your take?
I think it's the right ruling. I mean, I quite frankly am a little surprised by it. I didn't know if it was going to go that way because corporations are generally not entitled to religious rights protections.
It's for individuals.
But this is interesting. I think it's a very intellectually astute ruling because what the court said is that just because an individual or a group of people decide to incorporate their business, they don't, by that virtue of that, lose their independent and individual religious rights, which are really protected by the courts.
And let's face it, corporations are run by people.
Corporations are run by people. Right?
Yeah.
I'm not talking about IBM where there's millions and millions of shareholders. This is really a mom and pop family business in Poughkeepsie, New York, a small town that is a religious little store, an outlet store that adheres to certain policies, and they should not be compelled to give up those beliefs the same way someone who believes in contraceptive,
right.
Or a different religious belief.
Why should they be forced to pay for contraception for their employees when they don't even believe in it?
Right. Exactly. There's no fundamental right to work at that particular location.
Right.
If you as an employee don't like their policies,
don't work there.
Go work at Macy's or something.
And it's interesting. You make a good point in terms of, look, this is not IBM. So I wonder if the court would have ruled the same if we were talking about a large multinational organization, publicly traded, with lots of constituents, shareholders, hundreds of thousands of employees, as opposed to a small company privately owned by individuals who have their religious beliefs.
I think no way is the answer.
You think no way?
I have not read the decision yet, but from hearing what I just heard, it is a narrowly tailored decision, meaning it's really specific to the facts in this particular case, which are unique. This is not IBM, and it's a little mom and pop family operation. So when I hear the words narrowly tailored, that means this is a decision that really will apply uniquely to this set of circumstances and facts. Narrowly tailored doesn't generally shoot wide and spray wide and give coverage and sort of comfort to others. I mean, you have to look at the facts of this case.
Rich Edson, any thoughts on that in terms of, Hobby Lobby, obviously a small company run by individuals who have their religious beliefs. They're basically saying, look, why should we pay for contraception for our employees and be forced to pay for it in the Affordable Care Act when these are our beliefs, we don't even believe in it? But would the same ruling have applied to a large multinational with hundreds of thousands of employees, hundreds of thousands of shareholders?
You would think that in the reasoning of the court that that the number of employees they would think on the court would be almost irrelevant to the effect. And one more line here, Maria, on just how narrow the scope of this is or how large it is. We do not hold, as the principal dissent alleges, that for-profit corporations and other commercial enterprises can, quote, opt out of any law they judge incompatible with their sincerely held religious beliefs. So the court in Alito making clear here that this only deals with contraception and the requirements to pay for contraception under the Affordable Care Act that HHS has mandated. So that's just one little bit of information here that we're getting as we read through this decision.
The decision that we want to talk about, Joe Tacopina on set with me, is the idea that those working from home health care, do not have to contribute to union dues. Any thoughts on the winner here?
You know,
from the Supreme Court.
You know, again, not knowing where the court's ever going to go, and these are all relatively new issues we're all grappling with both as a court and society. You know, I think people who are employed, if they have the benefit from work from home, if they're still under the employee contract and are unionized, are going to have to chip in.
If you're a part of the union.
Yeah,
what if you don't want to be part of the union?
You know, I think it's going to depend on that particular employment contract and that union. I mean, these are issues, again, that we're starting to figure out as we go. But I think there's some open questions as to that.
Is this a big blow, Rich Edson? Is this a big blow to labor?
I wouldn't say it's a big blow to labor. I would say that it just takes away one of their avenues for trying to beef up their memberships, and memberships that, at least in proportion to the workplace, have been dwindling for generations now. This was their attempt to organize people paid by the state who are personal home workers, who are not full-time employees. And so what the court holds here is that essentially if you are contracted out, you're not a full-time employee of the state, then you can't be underneath the state law that says, okay, if you're in a union shop, you've got to join that union, you've got to pay dues. So not a huge blow to unions. They didn't disrupt the entire system of forcing a number of government employees to join a union and pay dues, but it does remove one specific avenue to add to their membership rolls. And
Joe Tacopina, of course, the Supreme Court wrapping up its sessions today for the summertime. That's why we're focused on these. These rulings have a big impact on business, and that's what we want to see in terms of the impact overall.
Yeah, and like this last ruling, for instance, there's a distinction, and the Supreme Court's always really fond of carving out particular distinctions. In this case, non-full-time employees. That's different than a full-time employee who has the ability to work at home for whatever reasons. Right. In a union shop. I mean, it's just a very different scenario here. So.
You want to be aware of the specifics, obviously.
Absolutely.
Joe, good to have you on the program. Thank you so much for your insights today. Joe Tacopina. Rich Edson will be covering and checking in with you as the news develops. Thank you as well, sir. Still to come.